All right, welcome everybody to today's webinar. My name is Steve Mahoney. I'm a mentor with the Greater Hartford chapter of SCORE. Today, I am joined by Wendy Estela. Wendy is going to be taking you through today's topic: is your worker an employee or independent contractor, and why does it matter? Wendy, I'll turn it over to you.
Great. Hi, everyone. Thank you for coming today. My name is Wendy Estela. I'm a partner with Kahan Kerensky Capicella. I have been an attorney for 25 years, and I work exclusively with small businesses. And I deal with this question all the time in various forms. I do work across industries, and I do have many clients that are in the service-based industry. So I'm happy to answer any questions as they come up, or at the end, whatever makes sense. I've asked Steve to kind of moderate those questions and interrupt me if necessary. And I encourage you to ask questions because the information is a little dry and it almost has to be fact specific to start getting into a little analysis. So with that, I'm going to start with the title. Is your worker an employee or independent contractor, and why does it matter? The first thing the reason, you might wonder, why do I say is your worker? Well, I hear all sorts of things. I hear people say, I need to hire a 1099 employee. That's totally wrong. I really try to say worker because you are hiring workers, and whether or not they're an employee or independent contractor, to answer the question, it does matter, and it matters for a lot of reasons. So the things that we'll talk about today are why proper classification of your workers matters, the terminology, the various tests that you can apply to determine whether your worker falls under falls within the definition of an employee or a contractor, Connecticut specific test, consequences of misclassification, best practices, and when to ask for help. And one other item in there that I will touch upon is kind of the roundabout way that you find out about misclassification. In Connecticut, it's very difficult, if not impossible, to get the Department of Labor to come and tell you ahead of time whether they believe your worker is an employee or a contractor. You really only find out if you've been audited. The IRS does have a process where you can request their analysis of how your employee or contractor your worker should be classified. So for worker classification, this is really a critical decision for business owners. You need to properly classify your workers to comply with many laws and to avoid penalties. Some of the laws are employment laws, discrimination laws. The penalties come from a number of places, including the IRS. And the reason it's important is because if you have an employee, they have various protections under employment law. If you are working with independent contractors, they are really looked at as a separate business. They don't get the protections of employment law. Those workers are looked at as separate companies. So again, when you're looking at everything, you're going to really turn to that worker and say, you're a separate business. This is a business to business transaction versus a employer-employee relationship. And many times those workers have to have their own insurance and a number of other things in place for protections for them, but ultimately for you as well. So it's very important to know these differences between employee versus contractor when you're hiring your first workers. Definition of worker classification, that is basically classifying workers or as employees or independent contractors based on criteria. And we're going to talk more about the consequences of misclassification, which include lawsuits for lost wages and benefits, IRS penalties, and reputational damage. So one of the ways that when you're looking at, hey, I'm hiring an employee, or excuse me, I'm hiring a worker, is it an employee or is it a contractor? There are a lot of different ways to figure that out and a lot of different tests that apply by different authorities. So a few that we'll talk about today are the IRS, the U.S. Department of Labor, and state of Connecticut. There's recently been case law in the state of Connecticut that interprets these provisions. So the IRS test there's actually, if you Google it, you can find the 20 factors that the IRS uses in determining behavioral control, financial control, and the dynamics of the relationship you have with your worker. Again, those 20 factors that you can Google fall within these three general categories. So essentially, if you as the business have control over the worker to the point where they really look like another employee. Whatever you call them, if you try to call them a contractor, it doesn't matter. It really, what we're going to be looking for is, does that individual have the ability to set their own schedule? Can they come and go as they please? Do they have their own insurance? Do they really operate their own business? Do they have other clients? Questions like that are the things that the IRS test looks at. As far as behavioral control, that's exactly it. I mean, can they come and go? Do they go to staff meetings? If any of these questions are answered in a way that they're starting to look more like an employee, then they're not a contractor. Financial control would be, how are they paid? Do they send you invoices, or do you pay them through your regular payroll process? What does that financial relationship look like? Also, do they have other clients? Can they make money from other people? Are they exclusive to you? Questions like that are asked to see what that relationship is from a financial standpoint. And those two also kind of fit in with that relationship dynamic. So basically, these three bigger areas are what the IRS looks at. And you can break each one of those factors into smaller parts to get a better idea of what type of status you have with a worker or business. So with the IRS, if you're not sure what your classification is, there is a form that you can fill out and send to the IRS, and they will assist with the determination of status. And it's the form SS8. So that is a positive that you can get that information ahead of time so you can avoid some IRS penalties. The US Department of Labor, they also have a test. And really, it's similar. All of these tests are very similar. And I would break it down to say that they all come down to the amount of control and independence that the worker has. So again, that's going to be the overall test: independence, control, direction of the worker. And as you would guess, independent contractors need to be independent. So here's another series of questions or steps to go through to see where your worker falls. Is there an opportunity for profit or loss for your company, depending on the skill level of the person? Investments made by the worker and potential employer, if any. So, are you paying for them to go to school for you, or paying for training? Look at things like that. The degree of permanence of the work relationship. Do you have independent contractors that have worked for you for 3 years, 4 years, 5 years? Again, that long-term relationship is going to start looking more like an employee relationship. The nature and degree of the control over the worker's duties. If you are heavily managing your worker, you're revising their work, you are giving them feedback, and that's starting to look more like an employee versus the contractor giving you a deliverable because they're truly an expert and you hired them for a very limited scope. Look at that kind of control over the duties of the worker. The extent to which the work performed is an integral part of the potential employee's business, and the degree of skill and initiative involved in the work. I'm going to try to give a few examples as we go. I had one client who was a salon, okay, and they offered many services on their website. And one of the things they offered was lash extensions. Okay, so they offer that in the normal course of their business. So the question is, if they hire a lash artist, is that person going to be an employee or a contractor? She works at various different places, not just this one salon. And if you really go through the various tests that apply, and we'll get to the Connecticut test as well, because the website offered that service and it's really it's an integral part of the business, even though that person just shows up maybe twice a week to see a few clients, that's one of the factors you have to consider, because really what she's doing is it's an integral part of the business. So things like that you have to look at. And you would think that because she's only there twice a week for maybe 2 hours at a time, that maybe she's not an employee. Like, it doesn't seem like she would be. But when you look at the different factors, especially one like this, she's an integral part of the business. Why would you advertise that on your website as one of the significant services you offer. So things like that you have to look at. And, if you look at other service businesses, you can look at like a media company, and maybe the company is offering podcast services. And if that podcast service provider isn't really part of the business, you have to consider how you advertise that. So these are things to consider, really looking at your core business, things that you're offering, and the way that you offer it. So Connecticut's ABC test is similar to the DOL test and the IRS test that we just mentioned. It comes from a case, Vogue versus the administrator. So if you really want to read it, you can look that up. The purpose of the ABC test is to classify workers. And here's the thing in Connecticut and in general, most workers are presumed to be employees unless all three parts of the ABC test are satisfied. So in Connecticut, we'll go through the prongs of the test. But in Connecticut, unless you satisfy those three prongs of the test, your person is an employee. And in Connecticut, the Department of Labor will only determine status as a result of an audit, which is fun, right? So part A, freedom from control and direction. I mean, this is the theme we've seen with the other tests, direct and control. Here we call it control and direction. You really have to have your independent contractor worker truly be independent. They've got to look totally different than other workers. They cannot do the things that your employees are doing. They have to be free from controlling their work. In their contract, it has to say that they are, it's independent, and in the way that you execute that contract as well. And so an example of this would be an individual setting their own schedule, determining how to complete their tasks. If they really have that autonomy, they're likely an independent contractor. Part B, outside the usual course of business. The work performed must be outside the usual course of the employer's business or at a different location. Again, the example of the salon. If this person said, hey, we can connect you with someone who can assist you with lashes or some other beauty service, and it's not part of our salon, and we'll connect you with that person. We have good relationships. We'll send you elsewhere. We don't normally provide this service. That's the way that salon owner could go about ensuring that the person is viewed as an independent contractor. And examples of work locations. So another example would be an electrician. So you have an electrician working at a retail store versus an instructor giving lessons at a golf course. Chances are the retail store that brought the electrician on to do some work with a specific scope, that's going to be an independent contractor. Whereas an instructor giving lessons at a golf course, golf courses offer lessons. So chances are that person is going to be an employee. And then part C this is, I'd say, probably the most important step, and also one that the independent contractors often lose sight of. So the independent contractors are really separate businesses. They are independent businesses. It's often one person. It's a sole proprietorship. They don't have an LLC, but they really have to be independent. And when you as an employer engage with an independent contractor, you have to take that step to ensure that they truly are an independent business, even if they say they are. So the individual must have an independently established trade, occupation, or business. Now, why it's important to you as an employer is because if that person is injured at your job site, your workers' comp policy doesn't cover them, the independent contractor. So the independent contractor has to have insurance to cover themselves if they're injured at work. The independent contractor should have some sort of insurance in place in general, like a general business policy. All of benefits, you're not providing benefits to an independent contractor. So it's very important that you as the employer, when you're engaging with these independent contractors, you're verifying that they truly are independent businesses and not just individuals who want to say they're independent businesses because they want to get paid without having withholding. So that's a very important step. I've seen it many times. I've got one client who operates a type of school, not an education school, but more of like training. They do like wilderness stuff. They have trainers that they hire, across the country to do things. And these individuals are independent contractors. They fit every test. But I've had my employer, my client who's the employer, ask me like, well, he wants to know, does he have to get insurance? Well, yes, he does. And they all have to run these businesses separately, because a lot of these independent contractors, like I said, they love the ability to have tax write-offs. They love the ability to get a pay, like what they consider a paycheck, without those withholdings. But what they don't always understand is that they don't have any coverage for risk that comes up in the course of, what they might relationships. So it's I'd say that's sort of like the practical side of all of this, is that you as the employer have one set of risks, but the independent contractors also have risks, and a lot of them don't fully understand it. Now, it's not on me, who works for the employers, to counsel the independent contractors, but it's on somebody to make those people aware that they've got to also run their business as a business. So again, an instructor with an LLC providing lessons at multiple locations is likely an independent contractor. But again, having that LLC, having the insurance, having their own curriculum that they offer, and having, other clients other than the main employer, the business, that is an independent contractor. So a couple of other things that come up with employee versus contractor, and I think the way the questions come to me are, how do I do it? How do I do this? I'm going to hire an employee, or I'm going to hire a contractor. I'm going to engage a contractor. So in Connecticut, we're an at-will state. So if you bring on an employee, typically you write them an offer letter, and that's it. You don't need a contract. There are situations where employees that are at will do have contracts, but typically you don't. You have an offer letter, and you'll have an employee handbook that outlines the rules of the business. And typically that's the employment arrangement. When you terminate your employee, typically there is a payroll process where they say, here's your last paycheck, and this is the last day of your work. And this is the process for unemployment if you're qualified for it. And if you're not, then you're not, because you're terminated for cause. And that's the offboarding process. So I'm sure everybody's familiar with that. When it's a contractor, it's different, because it's a contract that you're just terminating. So again, where the lines are blurred is that a lot of time the contractors start to look and feel more like employees. They augment your staff. You see them around, they're people. It's hard to imagine it as like business to business, but really, when an independent contractor arrangement has run its course, there is a written contract. There's a process in that contract for terminating the contract. There's no handbook. You are literally just terminating your agreement, and that's it. So it's important to understand those distinctions. Again, I have people that will say, well, I had somebody reach out to me because they wanted me to help them terminate, like fire a 1099 contractor. And I said, well, what do you, what do you need help with? And they actually went through like exactly what a layoff would look like, because they had mismanaged their arrangement with this worker to the point where the worker really thought that they were an employee, but they did have a contract that's an independent contractor. And it was just like a very delicate situation to kind of unwind it, because these mistakes happen all the time, and you wouldn't be alone if you've made them. So the consequences of misclassification, this is the scary part. Keep in mind, it's easy to fix it if you've done it wrong. And you just don't want to be in this situation. So misclassification, wage law violations. So this is one of the riskier areas. If you have a worker that is classified as an independent contractor, they are really an employee, and they've been working, say, 50 hours a week, 50, and you've just been paying them per their contract. Well, if they would be entitled to overtime pay as an employee, you're now on the hook for those extra hours that they should have been paid for overtime. And if that employee hooks up with the right attorney, or excuse me, that contractor connects with the right attorney and brings a lawsuit, those are very attractive lawsuits to attorneys because the attorneys get a multiple of the damage. The client gets a multiple of the damages, and often the attorney's fees are awarded to the client as well. So who pays that? The employer. And, yes, you do have insurance for this in most cases, but you don't want to be calling your insurance company with these issues. You want to do things the right way. But those are very expensive cases, and they're attractive to attorneys. So very important to keep in mind that you'd be paying not just once, but twice, sometimes three times, like a treble damages for failing to pay overtime. And also you can have claims from your employees or your workers, excuse me, for failure to pay benefits. I mean, this is big stuff. Unpaid employment taxes. You may face penalties for failing to withhold. So that's, self-explanatory. Nobody wants to deal with that. I-9 violations. So there can be penalties for failing to maintain I-9 paperwork. You can also have issues with workers' compensation. Oftentimes your carrier will audit you for workers' comp and see who's who and see, what you're paying for. So you can face penalties if you have somebody who's truly a worker, an employee, excuse me, they're not covered by workers' comp because you haven't paid for it. That's a big issue. If that person gets injured and they don't have their own insurance, they thought they were an employee, you didn't cover them, that's an issue. You don't want to be in that position. The benefits, the failure to include employees in benefit programs such as 401k, health benefits. You do not want these lawsuits. And anti-discrimination violations. So think about this. If you have an independent contractor who is misclassified, you can terminate them for any reason because it is your contract. You're terminating them per the terms of your contract. So the protections that apply for anti-discrimination based on your gender, your race, your religion, all of those things do not apply in a business-to-business contract. So if you have been misclassifying your workers as independent contractors, you've basically stripped them of those protections. Now, I get it. You probably haven't done it on purpose, but think about the more nefarious situations where employers have done those things on purpose so they can just really dispose of workers quite easily. So these are consequences that can happen, that can flow from misclassification. Failure to provide job protected leave. In Connecticut, we have a paid leave now that applies to employees, not contractors. And you also have the federal law, FMLA. These are benefits that have a dollar value and that also protect your job. So if you've terminated a contractor because maybe they haven't done a great job, maybe that contractor is dealing with their loved one's illness or their own illness and they've really failed in how they perform. If you've terminated them, and they ultimately could have been classified as an employee, that's an issue. Okay. So, and then there's also different notices. So if you have a major layoff, you have to provide notices. Different laws that exist to protect the employee don't apply to contractors. So the best practices for employers, it's tricky. Okay. This is not easy. I would say you really do have to proceed with caution. There are a lot of resources out there. This is a topic that isn't a new topic. You can read ADP alone. ADP, the payroll provider, has a lot of information on their website about this. I would say that you probably can get 90% of the way with resources that are out there. And if you can't figure it out for yourself because you have, okay, your situation isn't black and white, you have all these different factors and you really need advice, contact an attorney. That's where the attorney is going to be able to walk you through things and maybe suggest how to adjust your arrangement with the worker so that you don't run afoul of the laws. Because again, it's it's what I have found is that it's very fact specific. So when you read the cases, and in particular the Vogue versus Administrator case, if you read the cases of how the Department of Labor really analyzes all of this, I mean, they get down to such granularity. The case that they had was also, I believe that one, and I read a few, so I might be getting them confused, but one of the cases I read was talking about, again, a salon situation where somebody was renting a chair, or they thought they were renting a chair. Okay. And they were in there running their business, separate business within another business. And the person who was renting that space didn't have their own key. And they also had to use the credit card processing system of the main salon. Those are two facts that really stuck out to me. And for those reasons, they were looked as being too intertwined with the main company, the main business, and they weren't viewed as being independent because they couldn't come and go independently. We talked about that factor. And because they were stuck with the credit card processing equipment of the main salon. Those are major issues that you wouldn't think would be major issues when you're doing this analysis. And the part that's tricky is that, as you could see, the best practices are have a written agreement. Okay, that's great. You can have a detailed independent contractor agreement as definitely a best practice. But within that, you have to write it so that it doesn't run afoul of the law. So you can say it's an independent contractor, but if it looks like a duck and walks like a duck, the IRS, the DOL, and the state of Connecticut are going to say that, it's a duck, no matter what you call it. So that's where it can be helpful to work with an attorney just to, kind of get the sanity check. But I would say, and as a tip for how you work with lawyers, I would say get it as far as you can to where you think it's right, and then present that to your lawyer so that you're saving money on lawyers. There's, like I said, a lot of free information out there. And that's the best way to work with a lawyer in this type of situation. So in conclusion, the proper classification is crucial. Compliance with laws and avoiding penalties is what's going to allow you to focus on your business and not on this other job you take on as entrepreneurs and business owners of managing people. No one likes it. I'll tell you that too. Across the board, every industry I work with, no one enjoys the management of people and this type of stuff. Okay. And again, you're going to educate yourself as much as possible, but when necessary, talk to your attorney, talk to your accountant too. I feel like accountants know this as well. And that's about it. I mean, I welcome questions because, again, this is a very fact specific type of discussion. But that's the general law about contractors and employees. And I'd like to, answer any questions you have.
All right, great, Wendy. Thanks. We do have a couple in the Q&A box, and I'd encourage others, if you have questions about this topic, please type them in the Q&A box, and we'll get to them. The first question is from Rosemary, and as asked about the new changes to the Fair Work Act, and do you know how this would affect subcontractors? Is this something you can answer?
I don't know about that. I'm not prepared to answer that specific question. If there was something very specific, I could answer it. But
Okay.
I don't know. I'm sorry.
All right. If you have a more specific question, Rosemary, please type it in the Q&A box. I did see that we had somebody raise their hand. We're actually just taking written questions today, so if you could type your question in, that would be great. The next question is from Bob. If a company has a handbook to educate the contractor on the industry or the company history, would this be considered a violation of the 1099 status?
Well, what's interesting there is that the handbook typically can't apply or doesn't apply to the independent contractor. So you typically have, when you have a handbook and you have a W-2 worker, you have them sign off on it every so often. And you're an at-will employee, so you have your handbook, and you don't have a contract with those workers, your regular employees. You don't have a contract. But what you can do is every year you can keep changing your policies and procedures and issue a new handbook, and they sign off on it, and that's what applies to their job. So that if you did that with a contractor, you're essentially amending the contract with them. So the way it works is either, you either have employees with the handbook or you have contractors with the contract. And what I would recommend in that case is take the part of your handbook that you really want the contractor to understand and follow and dump it into your contract, like make it an exhibit. Don't call it employee handbook, call it something else. Okay. But make it an exhibit to your contract with your contractor, because you don't want to blur the lines of having a contractor signing off or being in receipt of an employee handbook. Does that make sense?
It does to me. I think it goes to that. It's you want to make sure that it's not just the actual arrangement, but the appearance of the relationship as well, right?
Absolutely.
It's just kind of how it's structured versus also the appearance of potentially going the wrong way.
Absolutely. And the thing is, I mean, I don't want to create a situation where you're adversarial with your employees or your workers, but you really can't give your contractors any ammunition to go to some attorney and say, well, I was misclassified for 5 years while I was a contractor for them. They owe me
Right.
5 years of whatever, benefits, 401k contributions, like all of those things. You want to keep it as tight and clean as possible, because that kind of lawyer is bad. It's bad for businesses.
Right. Okay. Um, the next question, if a company insists that a candidate be incorporated to work with a company, is that sufficient protection?
It's partially, it's not sufficient, because
Because
again, you can have.
you really need to pass all parts of that test, right?
Correct. Yeah, because you can have an individual and you'll say, listen, I mean, I've seen this situation too, where there's somebody who's been an employee for years. Okay. And all of a sudden the business says, well, my employee wants to switch to being a 1099. They want to start their own business now. Okay. So let's say that somebody's been an employee for 15 years and tomorrow they set up an LLC with the state of Connecticut, and now they are doing the same exact thing, but they call themselves an LLC. Nothing else has changed. That's not sufficient. If that person, organized it as an LLC and then took on multiple clients and maybe rented a space and had business cards and really was marketing themselves as a separate business, that would probably be sufficient. But just the paperwork alone is not enough.
Right. Right.
It
Okay.
really comes down to, I mean, you legit have to be a separate business with other clients. And as the employer or the business, you've got to be okay with that independent contractor doing that. A lot of times these arrangements are such that the business doesn't want that contractor. Like they really want them to be exclusive. If it's exclusive, they're probably an employee.
Yeah. I
And
think the
believe me,
important,
I represent businesses. I mean, I love the idea of starting, I love the idea of contractors. It gives you a lot more flexibility, but the flexibility can't outweigh the risk analysis. And if you're in a situation where you really have an employee that you're wedging into the role of an independent contractor, just proceed with caution, because that can come back to bite you.
yeah, I think what was eye-opening for me is that it's important to remember that the default classification is an employee.
Oh,
So
yes.
you have to meet all of the criteria in order to qualify as a contractor, right?
Right. Right.
Yeah.
And what's interesting is you might not deal with this issue until you terminate a contractor and they go to apply for unemployment. And you get this notice and you're like, whatever, they were a contractor, but now you're dealing with it. And like all of a sudden you're in it. And now you've got to tell the story of why they were a contractor and not an employee. And a lot of these, these unemployment hearings and the law in general very much favors the worker. Even when you look at workers' comp, I mean, if you have an injured worker, think of this scenario too. Let's say that it's a construction company, okay? And there was some trade that was a one person show. And you said, okay, yes, they're an independent contractor. You, as the business, didn't verify that they have insurance, have their, all of this. Now that worker gets injured. Okay. So now you have an injured worker. Let's just say it's a broken leg. Okay. They go to the Workers' Compensation Commission and they file a claim. They say, I was working for XYZ company. Oh, were you an employee or a contractor? I don't know. Well, workers' comp, I mean, look, they want to find coverage for injured people. So you have to assume the law is trying to favor the little guy here because that's just how it works. I mean, across the board, you're going to see the law favoring and kind of like starting with a presumption that the worker is an employee for, workers' comp, for benefits, for overtime, all of that, because who gets taken advantage of typically? The little guy. So again, when you know that that's what you're working with, it makes the analysis a little bit easier. But
Right.
really, things like the way you pay, the way the key to the building. I mean, you think that these things are really granular. They matter. They matter. Business cards, like let's say you have a contractor you give a business card to, and it has your business name on it. That could be used against you. I
Mhm.
mean, it's very granular when it comes down to the details of these arrangements.
All right. Next question. Do students who are granted seasonal internships qualify for contractor status?
That I can't answer, and I know that there's very specific new rules about it. So I'm going to say that's a little bit outside the scope of my discussion today, but I definitely know that that's one worth calling an employment attorney about. I just don't know the answer right now. What I've been told is that you have to pay them. There's no more unpaid internships. I don't know how true that is or not, but I'm not specifically an employment lawyer. I'm a business lawyer. And to me, that's a very specific employment question. I apologize.
That's all right. All right. This is a question that I was thinking about because all the advice you're giving is great. And especially for somebody who has not yet started their business or not yet hired a worker, these are all the steps they can take and all the things to avoid. But what if you're already in the middle and you think you might have
Yeah.
a problem? So Thomas has a question. What does the process of converting misclassified independent contractors to employees look like? What do you do if you're in the middle of it and you think you got a problem?
Yeah, there's probably a few things you can do. I mean, first I would have a conversation with the worker and just be very clear about it. Perhaps work something out directly with them, and you know that they're comfortable. You can definitely reach out to the Department of Labor for some guidance, because even if you were to work something out with your worker, your employee, if it wasn't sufficient to compensate them for how they were basically taken advantage of, right, they're going to still have a recourse with the Department of Labor. So I would say in that case, your best bet would be to reach out to Department of Labor and say, hey, we have this situation. Let them help you with it. I would also talk to my accountant, because you probably have a tax issue with state and federal withholding that you have to make up for. So I think that those would be the ways to do it. I mean, you at that point, you're making it very clear that you weren't doing it intentionally, like you're coming clean with it. So typically, those organizations are going to work with you to get it right. It happens every day. You wouldn't be the only ones that were in that situation. But again, I really would think it's going to depend on the length of time that this has been going on, the severity of it. I mean, run some numbers. If you think that you have not paid somebody overtime for 5 years, that might be something that you want to figure out with the Department of Labor, just so that you don't have a bigger issue if that person, goes there on their own. So, not that what you'd want to hear. Like, I want to say you could cut a deal with your worker, but it's just tricky because they have certain rights.
Right.
So
And the alternative is if you do nothing and you're audited, it's probably going to end up being a worse situation.
you're either
Right.
going to be audited or sued, right?
Right.
And that's going to be much worse. So anytime that you can self-disclose these issues, you're going to be in a better place.
Right.
And I would say that your penalties are going to be less because, again, they didn't find it and you weren't hiding it, and it wasn't intentional. It was a mistake.
Right. Okay. Our next question is, we were recently fined from the state of Connecticut for having classified a worker as independent when they should have been an employee. Are there federal fines that we were responsible for paying? How would we find that out?
Ooh, I don't know. I would say you probably are going to be taking a wait and see approach there. I would talk to your accountant about, again, IRS penalties, because at some point that's all going to be reconciled. So I would talk to the accountant and see what they can do to maybe offset anything. But really, I would just wait to see what happens. I don't think there's any way to just get an invoice from the government of what you owe. The government also, I mean, you don't know how they enforce any of their laws, right? So think about it. I mean, with just the IRS, the most simple, or income taxes, not everybody gets caught, right? And you don't know enforcement history. There's many laws on the books that never get enforced. I mean, not to throw everyone off, but there's also this Corporate Transparency Act that just came out. It was just effective January 1st of this year, and it requires LLCs to file certain information so the government can see transparently who owns what. Okay, and it applies to every single LLC that's in existence. Well, first of all, nobody knows about this law, or the people that do just because their lawyers have told them, but it's a law that applies to many people, and there are fines associated with it. Right now, so many people are not in compliance with it, but we haven't seen any enforcement activity. So, like there are laws that are on the books that don't get enforced. So I wouldn't go personally. I mean, I guess this is the part where we say this isn't legal advice, but I wouldn't say, "Hey, come find me." I would take a wait and see approach. I would be proactive with the IRS part of it. And I would definitely talk to my accountant, because they would be the ones that really are on the front lines dealing with a lot of those penalties.
All right, good answer. We got a couple more questions coming in. Before I take the next one, I am going to launch a quick poll for the folks who are on today's webinar. If you are interested in working with a SCORE mentor, you can complete this poll today. Just two quick questions. If you'd like a SCORE mentor, if you answer yes to the second question, you'll get an email from me later today on how to get a mentor. That's the only time you will get an email. We're not going to bother you. We're not going to harass you. So just wanted to put that out there before we wrap up in a little bit. All right, we've got a couple more questions here, and keep them coming because we have plenty of time. Next question. Generally, what is the cost for a small business to make this change if an organization has paid contractors for about 8 hours each week for a set of deliverables and decides to turn them into employees? What are the costs to consider?
Okay, well, I can speak to the legal cost of that, not so much like whatever your back benefits and all of that would be. I would think, though, I will say this, that I'm guessing that your payroll company, if you have one, could probably run some projected numbers on that, because if you really are working with an ADP or a payroll processor, they have so much detail and hours and timesheets that it would probably be pretty easy to figure out those numbers. So I would think, from a cost standpoint, that wouldn't be too expensive. For the legal standpoint, I could tell you that my firm and other firms I know, and I've got some great contacts who just do employment law, things like employee handbooks and contracts for independent contractors. These are things that we often do on a flat rate basis. We just give you a price and we say, we'll do your handbook for $2,000. Give you an independent contractor agreement and give you some guidance on it for $1,500. Like we can do these things on a flat rate basis because, number one, it helps us with you to build a relationship, and we want you to do things the right way. And having a strong template and policies in place is really important. So I think from like the legal standpoint, these are good investments in your business. And I would say that my guess, okay, if it were my business, I would think under $5,000 and under, you're going to get a handbook, a contract, probably an onboarding package and an offboarding package, so that and some guidance on how to use those things. And I think that's a very good, reasonable amount to expect to pay to, a mid to smaller size law firm to give you what you need to kind of manage those situations. And like, I'll tell you, the kinds of questions I get are, someone will call up and say, I have an employee I have to fire, and they're just kind of, they know the answers and they're walking through it, and they'll say, can I do this? Can I do that? Or I have a contractor that I have to terminate. Do I have to do this? Do I have to do that? These end up being quick discussions because I already know the client from having done their handbook or doing their contracts. And it's a lot of times with a lawyer, it's more like holding the hand of the client because they're just not sure. So a roundabout answer, but I do think you can get these things done pretty efficiently. And if you have to convert, the question was, if you had to convert from a contractor to an employee, I mean, that's really giving them your handbook or company policies and an offer letter. which, like I said, is included in, what I would think is basic stuff that a lawyer can do for you. The cost of years of benefits that you didn't pay, I don't know the answer to that. That would be very specific.
Right. And because I mean, I look at it as is kind of three groups, right? And you tell me if you think differently, but one is the kind of the establishing the legal compliance
Right.
framework we talked about. The second would be any back taxes that you
Yeah.
might owe. And the third might be any fines or penalties because you haven't been in compliance.
Right. And that's something you might never see, right?
Right,
But I will say, I mean, look, if you have somebody who should have been an employee for years and now they are, right? They were contractors, now they're employees. If you have like a 401k matching match, you're going to want to figure out what that would have been, because that's the other thing. And it wasn't even on the slides. I mean, if you're messing things up like that with your 401k, you could have an ERISA violation. I mean, many kind of ripple effects of this and the misclassification. You just don't want to go there. So yeah, I mean, again, I wouldn't worry about the penalties until you have to worry about the penalties. I would just worry about getting it right and just being very honest with your workers too. I think if
right,
anything, some of them might be disappointed, honestly, because like I said, a lot of them like to just get that check and be able to deal with it themselves.
right.
Everybody
If
wants
you've
more
got any
money.
tax, and if you've got any tax questions, obviously you consult with your accountant, right? They can
Yeah,
help you
for
kind of
sure.
sort through all that. All right, our
Believe
next
me,
question.
they deal with these issues just as much as lawyers do. It's very common.
Right, right. And nothing to be ashamed about, right? Because there's not like
No,
intentional malicious actions here. This is a matter
no,
of just
you're
understanding the
right.
clarification of the law, right?
Right. You go into business to do the thing that you're good at. Okay. What the thing that you typically don't prepare for or you're surprised by is what a pain it is to bring on workers or bring on help. And you learn that quickly, right? But no one likes doing it and it's difficult. It can be costly. No one likes it, but there's help out there. And
Right,
I like to point people to where you can get the free help. And that's why I say like ADP, all of these mentoring groups, talking to other people. It shouldn't be so cost prohibitive that you can't do it right. And I
right,
will say, like, for me, when I'm dealing with small businesses, I'm not saying we price differently, but we really do take into consideration what you're going through and the fact that a lot of these issues are repeat issues. So we are able to price in a way that's, it makes sense because we want to be able to help. And
right.
I know I'm not alone with that, and neither is my firm.
All right, got a couple very specific questions from Bob. Let's see if we can answer these. The first one is if an international software company has remote workers under contract in the US, would they be considered employees, though not directly controlled?
It's not enough to answer the question because remote workers they go through the same analysis. Like the fact that they're remote is not enough. Like
Right.
that alone doesn't make any decision. You still have to go through all those other questions.
And the directly controlled is one component, but again, you've got all of these qualifications that you need to look at.
Right, exactly. And what does directly controlled mean, right? What does that mean? They're not directly controlled because they're sitting somewhere else, or is it, what does their workday look like? Do they
Right,
have other clients? How do they send you an invoice to
right,
get paid, or do they get paid as part of a payroll process that just get a paycheck no matter what? Do they take PTO? Like, do they have vacation days that are paid? That's where I see the most mistakes is like I'll see an offer letter that's like sort of a hybrid of an independent contractor and an employee. And I think that's where well-intentioned business owners make mistakes. So they'll send something out as an independent contractor, but say, yeah, you're going to get all these paid holidays, you're going to get all these things, but so which one are you, right? It's really interesting to see what happens.
right. I think Bob's second question is going to probably meet that same criteria where
Mhm.
it's probably not enough information, but he's asking about, again, remote sales representatives that are commissioned, send the funds via an international card processing system, be considered employees. It's probably you got to look deeper at this situation.
Yeah,
Yeah,
it's going to be a number, there'll be a number of factors. Do they really, I guess my key questions would be like, are they doing this for other people? Do you have any, like, do you really rely on them to turn a profit? Um, like what does it look like? What does that role look like in the bigger picture of your business? There are going to be a number of questions like that.
Right.
If this is the front line of your business and you couldn't function without them, that could be problematic.
Yeah. Wendy, at one point during the presentation, you were outlining everything, and I think you said like doing some research on your own about these tests, understanding that the default answer is an employee, and you
Yes,
almost
for
need
sure.
to pass that burden of proof to prove it to be an independent contractor. To me, the advice I would give one of my score clients would be look at the criteria and ask yourself if you think you've met all the criteria to classify these as independent contractors. Do some work yourself, and then if you want to consult with an attorney to say, hey, check my sanity here, right? Do you think I've
Yes,
met the criteria
absolutely.
here? That would be a good business practice.
Yeah, because again, I mean, like I always say, I do not want to get rich off the back of small business owners. Okay. Like that's the last thing I want. I want people coming to me with real legal issues that are problems that we can sort out together. Where there are free resources, I try to point my clients in that direction. And in this case, it's really all out there. Okay. Now you may have questions, right, about specific things, but you really can bring it 90% of the way because you can find if you Google IRS test contractors, you're going to find a list of 20 questions. Okay. All of those things. And if you go through it, that's the analysis that the lawyer applies to. Now, you might get to one or two that seem like bigger or lesser than others. And that's where you might say, oh, I did this, I went through all of this, but maybe I could talk this through with a lawyer. And even then, knowing that you're not going to get a definitive answer where the lawyer's like blessing it, okay? Because a lot of it is left to what would happen if you were audited. So, it's a weird space because you can't just get an answer. Like the state of Connecticut, my client was trying really hard. She's like, I want to do things the right way. Will they sign off on this? And I mean, I was emailing them directly, specific people. I just wanted to have a trail because I knew they wouldn't give me an answer, but I was trying to get somebody to kind of say it looks good. And I mean, they said it over and over. We cannot sign off on anything. So basically, my client is in no man's land, hoping she doesn't get audited, but thinking that she did everything the right way in how she set up her independent contractors based on all the tests. So if if you think of a crazy way that it's set up, that's it. I mean, that's the regime. The IRS has that one form you could submit to get their take on it, but the IRS isn't the Department of Labor. So you have a number of different authorities that are looking at the same issue with different sets of rules. So welcome to the mess of it. And the underlying theme is you assume they're employees,
Right. Right. That's your default answer. And then if you can get
right?
over the hurdle and making them 1099 contractors. And then I think to your point,
Exactly.
there's going to be some gray, right? It may not be black or white, but if you can
Right.
work with the attorney to understand how to protect yourself as best you can and what the risk may be if there's
Right.
an investigation, right? Okay.
Right, exactly. Exactly. Use your attorneys wisely, right? I mean, don't waste money on things that you can do some self-help on. It's going to be better for you because we don't want you to spend your budget on these questions. We want you to call when there's a real when there's a real problem. Not that we don't want to help, but personally, like I hate sending a bill for things that I think are readily available answers. But
All
that being said, I do. I do when I have to, obviously.
All right. Well, I think that's enough for today. We're coming up on the top of the hour. Wendy, thank you very much for all of
My
your wisdom
pleasure.
and insight. You can see Wendy's contact information here. If you are watching this, if you decide to watch this webinar later on our YouTube channel, while you're there, you can subscribe to our YouTube channel. You'll be notified of future webinar videos as they are posted. I want to thank you all for joining today. Thanks again, Wendy. Enjoy the rest of your day, everybody. Thanks a lot.
Thank you.